The reporting procedure under the ICSCR is very much similar to that of the ICCPR, but unlike the Human Rights Committee, the Committee on Economic, Social and Cultural Rights cannot receive complaints. States submit an initial report within 2 years of ratification and periodic reports every 5 years. NGOs can also submit reports on countries to be examined by the committee. The committee has taken the step also to examine the situations in countries that have not submitted reports to ensure their accountability. The committee's annual report is forwarded to the Economic and Social Council. The reason that no complaints procedure exists for this covenant is that the implementation of economic, social and cultural rights is progressive in nature, and therefore violations would be difficult to identify because of each country's different level of development. However, it is becoming increasingly accepted that violations to the ICCPR are possible. For example, its non-discrimination clause is of immediate application, and so is the fact that states must take measures for the implementation of the covenant. This means that not taking any measure towards meeting their obligations or taking discriminatory measures or measures that are retrograde instead of progressive would constitute violations of the covenant. The theory of minimum core obligations also leads to the violation approach to economic, social and cultural rights. According to this theory, states are obliged to ensure minimum level of each right irrespective of their level of development. In fact, a UN working group has been working on an optional protocol instituting a complaints mechanism for the ICESCR. Under the reporting procedure as it now operates, states are required to submit report on the domestic implementation of the articles in the covenant once every 5 years. To assist states in that regard, the CESCR has adopted a set of reporting guidelines that outline the issues to be addressed by states parties. The reports, once submitted, are considered initially by a pre-sessional working group consisting of 5 members of the committee, which draft a list of specific questions regarding further information to be requested. When the committee comes to consider the report in plenary, a representative of the state concerned is invited to attend the committee's meeting and present a report. In doing so, the representative is requested initially to address the list of questions drafted by the pre-sessional working group. Thereafter, individual members of the committee ask further questions to which the state representative will endeavor to respond. At the conclusion of this process, which is somewhat inaccurately referred to as a constructive dialogue, the committee will draft a set of concluding observations in which it will lay out the principal subjects of concern to the committee and any suggestions and recommendations that it might have. One of the enduring criticisms of reporting system in general is their reliance on the cooperation of states, not only in terms of their submission of reports but also in their participation in the constructive dialogue. The unwillingness of certain states to cooperate in that regard has posed problems with respect to the ICESCR. For example, as of May 1996, there were 97 overdue reports from 88 states parties, and 17 states had failed to submit a single report in 10 years. The committee has taken action to address such problems by inter alia scheduling for consideration the situation in states in absence of a report. One of the major theoretical drawbacks of the reporting system as a system of supervision is its inability to respond to specific individual claims that might arise in relation to the enjoyment of the rights in particular states. To some extent, those claims might be championed by interested NGOs participating in the work of the committee, but thus far such action has tended to be limited to the field of housing rights. The lack of a formal complaints procedure has two main drawbacks. Not only does it deprive individuals of the opportunity to seek an international outlet for their complaints, but it also limits the committee's ability to develop a deeper understanding of the content of the rights in the covenant. As regards the latter point, the CESCR has attempted to remedy the lack of case law by producing general comments in which it attempts to outline its understanding of both substantive and procedural aspects of the covenant. As of June 2000, the committee had produced 13 such general comments, 7 of which relate to substantive rights, namely the right to housing and forced evictions, food, education, and the rights of persons with disabilities and the rights of the elderly. These all go some way towards elucidating the committee's understanding of the rights and obligations within the covenant, and indeed its perception of the difficulties facing states in implementation. The latter point was developed in particular in a recent general comment where the committee expressed its deep concern about the deleterious effect that UN imposed sanctions appeared to have upon the welfare of vulnerable groups in the target states. It reiterated the importance of the standards in the ICSCR and asked that those concerned with implementation take necessary cognizance of the ESC rights of the population affected. One of the major shortcomings of the ICSCR as a human right instrument is the fact that it does not possess the equivalent of a system for the consideration of individual or group petitions. Although the CESCR has recently drawn up a draft optional protocol to allow for the consideration of individual communications, it is unlikely that this will be adopted by states in the near future. The present situation, however, is not without its opportunities. First of all, individuals and groups do have the opportunity to submit information to the CESCR alleging violations of rights within the covenant, and this on occasion may induce the committee to ask states for a particular response. To some extent, therefore, the system operates in a quasi-judicial manner in providing at least a potential outlet for complainants. Secondly, it is apparent that there is a substantive overlap between the ICSCR on the one hand and the ICCPR on the other, and that if a state is party to the optional protocol to the latter, petitions in relation to ESC rights may be submitted to the Human Rights Committee. The clearest examples arising in practice have related to Article 26 of the ICCPR concerning equality before the law. In several cases, the Human Rights Committee has come to consider the legitimacy of discriminatory social security legislation in the Netherlands under that provision, notwithstanding the fact that the right to social security is found in the ICSCR, not the ICCPR. Other potentially fruitful overlap include the right to join and form trade unions and the right of members of ethnic, cultural and linguistic minorities to take part in the cultural life of their community. A similar situation prevails in relation to the Covenant Against Racial Discrimination (CERD), which has led in the past to certain ESC rights being considered under CERD's petition system. The ICESCR, part of the international community's wider system for the promotion, protection and enforcement of all human rights, is the only international instrument within this system that deals extensively with ESCRS. It is thus primarily through this covenant that the interpretation, implementation and reporting of ESCRs to be undertaken. It is maintained that though the covenant is an extensive assortment of rights, the broadness with which they are dealt and the weak, vague language of the obligations to undertake and enforce them a direct result of the ideological differences that engulfed the drafting process. It is further maintained that comparisons between civil and political rights and pursuant perceptions of ESCR as non-enforceable and not capable of immediate implementation still persist. These two issues are not only reflected in the legal and scholarly discourse developed to expound the covenant, but has also negatively affected the realization of ESCRs.